Thank you, Your Honor. May it please the court? We're here on an appeal of joint appeal of Jared Morrow and Gary Manning. They were both convicted of one count of non-supportive dependence and for failing to go pay for 26 weeks during a 104-week period of time.
Excuse me for just a moment. Are you Mr. Pelt?
No, I'm Mr. Simon.
Oh, okay.
Your Honor.
Okay, it's helpful. We have some names here. It's helpful if you introduce yourself.
I'm sorry, Your Honor. Okay, my name is Zachary Simenoff. I'm here for the appellate. I haven't done this in so long, so.
That's okay.
Okay, thank you. Essentially, Mr. Morrow and Mr. Manning were convicted, pled guilty to one count of non-supported dependence, a felony in 5th degree, for failing to pay during the 26 weeks to support their family member, for failing to pay court-ordered child support for 26 weeks during a 104-week period of time, as specified in this.
And did they have other child support rearages in this case?
I don't understand the question.
Didn't predate, well, I'm concerned about the increase from the child support that they owed to the total amount that the court found. Was that all cost fees, or did it include other unpaid child support accruing before this time frame?
It included child support arrearages prior to the indictment.
Okay.
The court awarded a restitution amount in its sentencing entry in the amount for Jared Morrow of $16,942.24, and in Mr. Manning's case, $29,447.80. Even though the amounts that accrued during the period of time of the indictment for Mr. Morrow was $4,578.72, and Mr. Manning was $5,089.68. The court's order of sentencing order, which was attached to a brief and in the appeal, states that restitution of past court-ordered child support arrearage in the amount of $29,447.80 was awarded. It doesn't break down what's the restitution amount. It just orders the amount of prior child support that existed at the time of the indictment.
That $29,000 didn't include the money that was owed during the 102 months, or it did?
It did include that.
Okay, so he owes $29,000 as of the date of judgment on this thing?
No, I didn't understand that. That is the date that they issued the indictment. That was the amount that was in the indictment that he owed at the time that the indictment was issued by the Lorain County grand jury. That was his back child support as of that date.
What was his back?
29 plus 5?
No, 5,000 was during the 104-week period of time. Without paying the child support, the arrearage, that's the total arrearage during the 2-year period of time. During the 2 years.
That's the indictment period.
Yes, the 29,000, the 24,000 was back child support.
Okay, right.
Your Honor, the issue before the court is it proper for the court to lump all the back child support together in a restitution award? And there's a 2-part test for your standard of review that's stated in State v. Williams out of Lake County. That's 2014 Ohio 65. And first, the court needs to go look to see whether de novo, whether the trial court complied with 29-29-18. And then the second is, did it abuse its discretion when it awarded the financial sanction under the sentencing statute? Your Honors, 29-29-18A1 specifies that restitution can only be for an economic loss caused by the proximate cause of the criminal offense. That's what, and I contend that's the time during the 104-week period the period of time during the indictment period. 29-29.01L defines economic loss as the injury to the victim as direct and proximate cause as damage to property, if it caused the death, the funeral cost. It does not include punitive or exemplary damages. What the court here did is essentially increase the restitution amount by ordering to pass through child support in there. It's unclear from his entry what's the restitution and what's not restitution. And I would even go so far as to argue that making the remainder condition of community control is in a sense making a restitution award, because if you don't comply with the conditions of community control, you can be imprisoned, and that's kind of the point of restitution. You order to pay restitution. If you don't pay the restitution, you can have the sanctions imposed.
Let me ask you a question. So
Sure.
are you suggesting that in order to get a judgment against child support, people who aren't paying, you have to file every 2 years so that you can secure that amount every 2 years? What is that, you're not tacking on past stuff?
Well, we're talking about the criminal offense of non-supported dependents. Obviously, there is always child support that's owed, and it's being collected under the child support statute. Also, the person that's owed the child support, or CSCA, could always go reduce that to a judgment, and then in the beginning, the garnish. I'm talking about the criminal offense, and that is obviously at the discretion of the state.
But to Judge Schaefer's point, would the prosecutor be permitted to, if we follow your analysis, every 2 years just indict him?
Absolutely.
For that period of what happened in the 106 week, is it 106?
Yes.
Yeah.
Yes.
So we have a multitude of suits every 2 years.
It could happen. It's clearly within the discretion of prosecutors.
But is that what the legislature really intended? And it may be that that's why the courts have indicated that once you place an individual on post-release control, you have this discretion to consider past child support that has already accrued.
Well, I think in Morrow's transcript, the prosecutor conceded my point on page 6, line 24. If when you get a chance to read the transcript, my understanding is that you don't get the transcript until after the oral argument. Essentially, my argument is that the court should be making an order that he remain current with child support, which includes an arrearage amount. The child support statute permits a percentage increase of your child support to go toward your arrearage. And we argued at sentencing, and I have, and my client has no problem saying you owe a restitution of the amount that accrued during the 104-week period of time. However, you also need to be current with the child support, including the arrearage payback amount. The issue is lump summing the full amount as payment for as condition of community control sanction. Essentially, these people haven't paid their child support for an entire 104-week period of time. It's questionable whether they're going to be able to pay their $5,000, let alone $29,000.
Let me ask you a question. Are they ordered to pay a minimum per child, or are they given a number and they're stuck with that? Or is there a minimum because, like in the case of Mr. Morrow, I believe he's not employed, right?
Mr. Manning wasn't.
Mr. Manning, is he just paying the minimum per month until he finds a job, or is he being dinged for the whole, I don't know what the number is, per month until, and now we're accruing stuff again?
Well, he would be paying what the amount for the for the child support that's awarded. He can obviously go in and seek a modification based on that. But right now, until a modification is issued, he is responsible for the full amount plus an arrearage payment, and that would be for any for however many awards he might have. In this case, he was charged under one order, and I believe that's all he had was one order. The second contention.
And you're close to your 5.
Oh, thank you, Your Honor. I'll reserve the rest for thank you.
May it please the court, my name is Preeti Kishman, and we filed a notice of substitution of counsel, and I'll be arguing on behalf of the state. of Ohio in this appeal. There are four main issues in this appeal. The first issue is whether the trial court abused its discretion when it sentenced defendants to the entire outstanding child support arrears existing at the time of the indictment. The second issue is whether the trial court abused its discretion when it determined that the defendants had a current and future ability to pay the financial sanction. The third issue is whether the trial court properly ordered the repayment of costs of prosecution. And the final issue is whether the trial court abused its discretion when it ordered administrative fees as a part of the defendant's restitution. All four of these decisions were proper, and I will address them in the order that I listed them. Now, the first issue is in regard to the arrears that were ordered in excess of the indictment period. In a felony non-support case, the trial court can order restitution in excess of the indictment period if it's a condition of probation. Now, in this case, the total restitution, including what accrued prior to the indictment period, was explicitly listed as a community control sanction. In the Hubble case, the court stated that a trial court could not include restitution in excess of the indictment period as restitution when it wasn't listed as a community control sanction, but in the judgment or in the sentencing entry, at both the cases at bar, it was listed as under the community control sanction as restitution and past order child support arrearage.
And what's the significance of that? I mean, just logically speaking, what's the significance of having it listed as a community control sanction and that permitting the court to go beyond the amount that's in the indictment?
Your Honor, it's significant because it's reasonably related to the defendant's rehabilitation. Now, in this case, it's a felony non-support case, and defendants, faced issues, the fact that they can't make these child support payments, and having them pay back these arrears is related to the defendant's rehabilitation. And the court in Hubble says that as long as arrears in excess of the indictment period is reasonably related to the defendant's rehabilitation, then ordering that sanction would be proper. Since the Hubble court really laid out what the standard is for when you can order arrears in excess of the indictment period, what the trial court did is correct, and the defendant's argument is really without merit. The second issue is in regards to both defendants' ability to pay their financial sanctions. The defendant had argued that, the appellant had argued that both defendants, the trial court hadn't inquired into the defendant's ability to pay.
In other words, it didn't ask enough questions about where
Yes,
they
Your
were going to
Honor.
work and how much they were earning, and et cetera, et cetera.
An inability to pay is an affirmative defense to a felony non-support charge. And the Brown case in the state's brief lays out what the defendant actually has to prove in an affirmative defense of inability to pay. Well, since it's an affirmative defense, the burden is on the defendant, and it must be proven by preponderance of the evidence. The Brown case stated the defendant both had to show that they did not have the means to provide the total support, and they made whatever effort they could to provide whatever was possible.
And so your position is they failed in their burden of proof?
Yes, Your Honor, and the trial court in both cases did inquire into defendant's ability to pay. Now,
What are we going to see in the transcript about that? You say it inquired. Are we going to find meaningful information in the transcript about how they responded?
yes, Your Honor,
Okay.
Your Honor, I would say that the trial court inquired into their ability, both the defendant's ability to find work and why neither defendant really provided credible evidence to why they couldn't find a full-time employment.
Well, one of them, I thought, was employed. Was it Morrow was employed? And Manning was not employed and had a felony conviction and sounded as if the court just basically said, get a job. Is that meaningful inquiry into the ability to pay?
Your Honor, defendant in Manning, I believe, had a felony conviction, but a felony conviction doesn't, completely prevent someone from being able to gain full-time employment. I mean, there are employers out there who specifically seek out people with a criminal background in order to give them some. And further, Lorain County has programs for people to be able to find work who usually wouldn't be able to find work in traditional ways. I believe neither defendant Morrow nor Manning really presented credible evidence why they couldn't work. I mean, just one felony conviction is not enough to excuse someone from having to find full-time employment. The appellant also argued in the brief that not only did the trial court have to inquire into the defendant's ability to pay, but it's required to hold a hearing. And just the relevant statute is Ohio Revised Code 2929.18E, and it says that the trial court may hold a hearing if necessary to determine whether the offender is able to pay the sanction. It does not require the trial court to hold a hearing. So by the plain language of that statute, the trial court did what was required and their determination was proper. Now, the third issue is in regards to cost of prosecution. The trial court did not abuse its discretion when it ordered the defendant to cost of prosecution. The relevant statute is Ohio Revised Code 2947.23A1A, and it states that in all criminal cases, including violations of ordinances, the judge or magistrate shall include in the sentence cost of prosecution and render a judgment against the defendant for such cost. Now, the appellant cited to another statute, 2919.21, that stated that in a felony non-support case, you do not charge the defendant for attorney's fees of the state. Now, in this case, neither defendant was charged attorney's fees. The defendant was only charged the cost of prosecution, which is really a term of art that means it compensates the court for the money that was used to prosecute the case. In no way compensates the prosecutor's office. Since the statute explicitly requires cost of prosecution, defendant's argument is without merit. And the final issue is in regards to administrative fees that were charged to both defendants. The trial court properly ordered the repayment of administrative fees and their restitution amount.
And this is the 2%, right?
Yes.
Processing fee.
Mm-hmm. Yes, Your Honor. The appellant's first argument in regards to the administrative fees is that they did not accrue during the indictment period and therefore were not really a result of the offense, since some of the administrative fees would have accrued prior to the indictment period. But the administrative fees were also ordered as a condition of probation, so they were proper. And then the appellant also argued that there was a double charge for because they're charged for both the current support payment and then when the arrears are collected. The relevant statute is 3119.28, and it actually defines what current support payment is. It's another term of art, and it specifically means the amount of support due an obligee that the obligor is required to pay. It does not mean what is actually paid. And this statute also states that the obligor shall pay the processing fee on both the current support payment, so what was due that month, not what they actually paid, and with every payment for arrearage. So it was proper for the court to order administrative fees for both the current support payment and every payment of arrearage. Also, just as a policy matter, it seems illogical to reward a defendant for not paying his child support on time. In fact, if the defendant had been making all his both defendants making all their child support payments on time, they would have been paying those processing fees just because they did not make their child support payments, they went to arrears, it seems like bad public policy to allow them to just get away with not paying those child support payments. And for all these reasons, ordering those administrative fees was also within the discretion of the court. Your Honor, for the reasons stated in the brief and oral argument, the State of Ohio respectfully requests the sentencing court's determinations to be affirmed.
Thank you.
May it please the court. Your Honors, just to address a number of the arguments that the state presented. With regard to the administrative fees, the charge is not supported dependence. The charge is not supporting a child or a family member by missing court order payments that were ordered for 26 weeks during a 104-week period of time. CSCA is not a victim here, and under the statute with regard to economic loss, they didn't. It's not an economic loss because they're not the victim in the statute. So just because they say that they want their administrative fees doesn't mean that that's an amount that could be ordered as restitution or really as condition of probation.
Isn't that 2% added on every month from the time you start, and you always pay 2% a month because that's what it costs to administer your child support? That's why you can't pay it directly, right?
It says that Your Honor, yes, the statute says that the CSCA can impose a administrative fee up to 2%, and they impose 2%. And then if a person misses their payment, that fee is then rolled into the child support. Then when you eventually pay the amount that includes the administrative fee, you then pay the administrative fee on paying the administrative fee because that's now been rolled into your support.
Well, anyway, but the state's point is that if you say, well, because you're behind 3 months, you don't have to pay the administrative fees for the 3 months that you're behind, so you can just now pay it on the one you're missing now. I mean, I get the point about the two. You don't get to miss your payments just to avoid having to pay the processing fee, right? And that's what the state's argument is.
Well, I understand the state's argument, but the fee is not punitive, and the way it's being interpreted and rolled in is punitive. Essentially, you're tacking on interest into your child support. The second thing is that the state says that with regard to the inability to pay, we're dealing with a sentencing statute, not in affirmative defense to the charge of non-supported dependence. There is an affirmative defense in the statute for non-supported dependence, which is inability to pay. That's waived when both of the appellants have pled guilty. What we're arguing here is that the court did not properly apply the sentencing statute in determining current and future ability to pay. Mr. Morrow stated he had a full-time job. The brief does not concedes that issue. Mr. Manning, both of them are felons, but Mr. Manning had a violent felony. He had been to prison. He says that he had not been able to get a job. He actually stated that he had given up looking for a job after quite a while ago because he was not able to get a job.
Well, what details do we have in the record of what he looked for and what he did?
The judge actually inquires about that.
So I'll see that in the transcript.
Absolutely, absolutely. I was just looking at when the state was arguing that. That is in the transcript. Also, so the state, with regard to count assignment 2, is just off base. They're applying an affirmative defense standard to the sentencing statute, and it's not the defendant's obligation to go prove by preponderance of evidence that they don't have an ability to make the payments. The reason in the sentencing statute is that this country does not believe in a debtor's court, and it's well understood that we want to make sure that defendants are able to pay their financial sanctions, or you're just setting people up to fail. So if you have an individual that hasn't worked in 5 or 6 years and has a felony and is been incapable to get a job, even one for minimum wage, then to go hit him with a $29,000 condition of probation, one, that's not rationally related to making him rehabilitating him. You're crushing him under a burden of a debt that he's never going to be able to pay.
Well, how's he gonna?
Sorry.
Well,
Once he
just got 30
says,
seconds.
once he says, I've stopped looking for work, then, what's the court to do?
Well, I understand that. It's a difficult decision for the judge.
Right.
But I think the judge needs to understand that if he's not working, he gave up looking for work, let's take a look at 5 years of probation at minimum wage. If you want to impute minimum wage, he's still not going to be able to pay $29,000. That's a lot of money for someone that hasn't, even a person that might be getting a minimum wage, Your Honor.
Well, he wouldn't be garnished that much anyway. By law, you're not allowed to garnish more than, 50 or 60% of your wages?
I believe so as well, but if you make it a condition of probation and he doesn't comply with that condition of probation, you're essentially saying at the end of his probation, community control, excuse me for confusing the terms, you're now facing prison because you haven't complied with the condition. That's why the statute is set up to go actually inquire and do a fairly detailed inquiry. And this court has found that has overturned cases because you understand that.
Doesn't the defendant, Mr. Morrow, Mr. Manning, both of them had the ability to go back to CSEA and have a child support recalculated, didn't they?
Yes,
Prior to any of this happening?
I'm not aware. I lose track of them once they're sentenced.
They could have done that at any time, right?
Many people, they feel overwhelmed. They go in, CSCA imputes amounts. They'll only review them at certain periods of time. You can only request a modification once every 3 years. I don't have any excuse or question about why they did or did not go back. I just know that as of the date of their indictment, that's what they're.
You are now over 2 minutes of your time.
Thank you.
Thank you. We will take the matter under advisement and send you a copy of our written opinion when it is issued. Thank you.
Thank you.